All right. Hello, everyone, and welcome back for our final event of the day. Pierre Devise will be moderating the debate on whether privacy should only focus on economic harm. Pierre Devise will be moderating the final debate on whether privacy law should only focus on economic harm. Pierre is an executive fellow and co-director of the Spectrum Policy Initiative here at Silicon Flatirons. Pierre?
Wonderful. Thank you very much. Somebody's rushing into the control room, and
oh, there you go.
Now you'll regret it. Now I'm really on. There is the motion. Privacy law should focus only on economic harm. Go to that bit.ly link and vote. We're going to have, the way this is going to work is we're going to have a vote now, which is why you've got SFC 2019 first. And at the end of the debate, you get to vote again. And so really, we're not trying to establish whether the yeses or the nos are the bigger number. We're trying to find out which of these two teams of superstars is the more persuasive.
Wow.
Because we're going to see how the votes have changed over the course of the debate.
We call it differences in differences.
This is a guy who's done economics. Differences in differences, yeah. So please go and vote now. That poll will be open for a few more minutes, and we'll see what the results look like when I've stopped talking, which will hopefully be soon. The purpose, as you said, you can see the title of the debate there. For those of you who actually keep form for the speakers, you would have looked at the program and gone, those are the people doing the pros and cons, really?
Flip it.
And that was just to see if you were actually reading the program. In fact, it's going to be the other way around. The purpose of this conversation really is to help you think through what the issues are. By staging a debate, these folks are all very expert in this. They're so expert, we could, in fact, have swapped them around, and they could have done each other's talking points, I'm sure. Also, remember, this is a debate, and so the debaters will be using arguments. You shouldn't necessarily assume that they're actually believing everything they're saying. This is a debate. We're airing these issues. And the last caveat is that we're setting this up as a binary choice. Binary choices are always misleading and usually wrong, but that's what we're doing today. So what we're going to do is we're going to have three parts to this conversation. First, we're going to have the two sides present their arguments, 5 minutes for each of the speakers. We'll then have 20 minutes where they get to cross-examine each other. And then we'll have a 10-minute closing round where each of them will get 2 minutes to close. And then we'll get you to vote again. And so the speakers that we have here in the order that we'll go in. First, we've got Jeff Mann on your left, who's the president and founder of the International Center for Law of Economics. He'll be followed by Paul Ohm on your right, who's a professor of law and associate dean of academic affairs at Georgetown University Law Center. Then Gus will speak in support of the motion. He is, he actually asked me, are you ready for this? And,
wow.
And I said, no, are you? And he said, and I guess I should say, are we ready to rumble? But he actually has a degree in economics. He's an associate professor of law and co-director of the Space, Cyber, and Telecom Law program at the University of Nebraska College of Law. And then wrapping it all up, we have Professor Danielle Citron, who's the Morton and Sophia Macht Professor of Law at the University of Maryland Francis King Carey School of Law. So that's the lineup. If Vanessa's here, we could quickly have a look and see how the poll has been doing. And since we don't really trust technology, right? Oops.
I'm going to keep it up.
So there we go.
It says two answers.
Oh,
reload.
Hit.
Hang on.
Hit refresh.
We're appealing to a very narrow slice of you.
Yeah.
So evenly split.
There we go.
There we go.
It is.
Oh no, there's no room for improvement.
Yeah. All right. So we've got yes.
Imagine if we go down.
Let me take a note of this. We've got yes at 16% and no at 83%.
God.
And actually, we've already got 98 votes. There may be ballot stuffing. We have had ballot stuffing in the past. But let's just as a backup, by show of hands, who agrees with the motion? Yes, show of hands, please.
This is who we have to talk to.
No privacy in this room.
I know, I'm looking at
Right, and then the noes. All right, thank you very much. So that looks about right. So let's kick it off. Professor Mann, 5 minutes.
Would it help if I told everyone they were fools? Does that help in the voting? I can't remember.
Yeah, usually does.
I can't remember how that works. Okay.
You're wrong.
Well, I think it would probably help, and I hope will help move some of the votes to talk a little bit about what it is I mean, and I hope Gus means, by economic harms. I think it's very clear, of course, that one can imagine all kinds of harms, physical harms, harms like some of the things we've talked about earlier today, revenge porn, things that are self-evidently harmful. What I at least mean by economic harm are essentially harms that are susceptible to economic analysis, to calculation. What I mean by, or what I intend to defend in of this proposition is the recognition that there are always trade-offs, especially when it comes to psychological and emotional and deeply difficult to quantify effects of conduct. And that economics provides a mechanism for trying to evaluate those trade-offs and assess the things that should be made illegal and by what mechanisms and to what extent they should be made proscribed. But to do that, we have to know baselines. We have to have some kind of definition here. We have to be able to identify, at least identify the thing that we're talking about. And as Casey mentioned this morning, ideally be able to actually measure it. But I would settle for just one of those. I would actually even settle for just being able to clearly identify the thing that we call a privacy harm. Because my sense is that the opposition to, here would take a position that supports making a harm out of things that are not only impossible to measure, but actually impossible to even identify, beyond, as I said, a few very obvious things that we could all agree should be harms. Again, I think the key here is that in focusing too much on inchoate harms to privacy, as if that has any meaning, that we lose the ability to actually measure the trade-offs. It's impossible in most cases to maintain a position that there are no benefits to conduct that might actually cause what someone could say are privacy harms. Take, for example, the collection and use of data for targeted advertising purposes. There are clearly some people who think that there is an inherent privacy harm in that. We can talk about what actual version of that would actually rise to the level of privacy harm, but let's just assume there is one, that there's information that's being shared without permission, let's say. But I don't think that you can suggest that the sharing of information without permission doesn't also confer some benefits. For example, there are at least some people, and I would argue probably most people, who all else equal might rather see relevant advertising than irrelevant advertising, assuming that, that's the choice they're given. I understand that some people may not feel that way, which gets us to one of the other problems of focusing on non-economic harms in the privacy context. Again, by which I mean harms that are not susceptible to a kind of identification and measurement. Humans are extremely different. We have extremely different levels of interest in, or we weigh very differently the benefits of conduct that might lead to the exposure of information and the costs of the exposure of that information. Where when it comes to things that one could put a monetary value on, which is not, by the way, what I mean by economic harms, but that's an easy example of things that would fall into that category. I think we can all say that $1 is a pretty well identifiable unit of measurement, and that nobody would rather pay more than less for anything. But you can't say that nobody would rather have less privacy than more privacy. I'm sorry, you can't say that everybody would rather have more privacy than less privacy, because having more privacy changes the nature of the product, of the service that you're getting. Again, precisely because there are benefits from the very same conduct that might lead to the sort of potential or actual exposure of information. So that trade-off, measuring that trade-off, is extraordinarily difficult. And I think Gus will later talk about some more sort of nuanced aspects of that.
And that's just as well, because your
because
time
my
is up.
time is up. Perfect.
Thank you very much.
Paul will talk about some
Professor
unnuanced
There you go.
aspects of that now.
The head prefect of House Hufflepuff.
Oh no, yes.
The game is
Continuity.
yours to lose, sir.
So I'm going to start with what's obvious and what's probably occurring to everyone in the room. It is true, Danielle and I did coordinate to make sure we had the same facial hair. I'm sure that jumped right off the page. If I'm doing my math right, there are 15 people I'm talking to in the room. I'm hoping not to lose any of the rest of you. And the 15 gentlemen, if I saw correctly. One thing I want to explain is there really is the tyranny of the adverb up here, right? They are supposed to defend the proposition that there's only economic harm that we should use in this broad ambit that we call privacy law. And I think that's a pretty kind of high standard to meet. So it's not our burden to convince you that behavioral advertising is bad, or that we ought to have privacy law that would change the kind of complexion of the internet economy that we've developed. No, we just have to convince the 15 of you and not lose any of the rest of you that there are some situations where we ought to have a privacy law that we don't have today that is premised on something other than traditional economic harm. So I'm going to do that in 4 quick steps, hopefully in 5 minutes. One, I want to be really clear that our opponents are defending the status quo. That today, economic policy, economic law dominate the way we talk about privacy in Washington, D.C. and in the state houses. And so what we're really talking about is, ought there be a new privacy law that does something that today's law doesn't provide? Number 2, the status quo is terrible. And to make this concrete, I'm going to give you a case study about location privacy. 3, why I don't think economic analysis is up to the challenge of dealing with location privacy in my case study. And then 4, a better way. I'm going to end on this kind of optimistic turn. Okay, so right now, the world we live in when it comes to privacy is a world, I believe, of companies run amok. We're privileging offensive and unexpected data practices in ways that contravene the wishes of users everywhere. This is leading to chilled speech and behavior, insecurity, anxiety, a learned helplessness. I think this is an easier message to deliver in 2019 than it would have been 3 or 4 years ago, given some of the headlines that we've seen. I might be wrong. The 15 of you may love the way that privacy is working out in our lives today. I'm hoping that you at least see that there could be an argument to something like that. Let me give you this case study. In the last 2 months, I mean, the problem with privacy is all you have to do is look back a couple of weeks to find the latest horrifying story. We have 2 stories that really did even surprise the kind of most cynical and conspiratorial privacy advocates. One in the New York Times, which really did, for the first time, kind of help us appreciate the sweep and the amount with which our apps are tracking our location in highly precise ways. Companies track up to 200 million devices, single companies that buy from different apps. These track your location accurate to a few yards. They track, for some people, up to 14,000 different pings per day. So it's this widespread market for location tracking. And we're not talking about big companies you've heard of. We're talking about dozens and dozens and dozens of small companies that are trying to monetize this data any way they can, and all of the attendant risks that come with that. As if that weren't enough, in the last month, and then especially in the last week, Motherboard has done an expose. I must confess I didn't know what Motherboard was before this expose, about the way that 3 telcos, so shout out for Verizon for not being in this list of terrible companies, T-Mobile, Sprint, and AT&T. They're using the technology, the E911 technology, that they were kind of urged by both the FCC and Congress to track the location of their users more often, and they're selling it indirectly, granted, to bounty hunters. So over 250 bounty hunters can buy this information, presumably to look for people who have skipped out on bail, but it's not even clear that that's necessary because the reporter in the story, for a $300 bribe, was able to buy this information. But then later on, they got the official price list, and it was $495 will help you track any one of these phones for a given ping. $12.95 will let you do it on an ongoing basis. Okay, so location privacy has run amok. We need a new law that regulates location privacy. We don't have to defend whether this should be a capacious law or a narrow law. We need a new law. And the question is it the tools of economic analysis that are going to help us decide whether or not to have this law? I'm probably short on time, so I'm doing okay?
1 minute.
1 minute. So if you had an economist who looked at this and they looked at the incentives and they said, maybe some people who are tracked by bounty hunters want to get tracked by bounty hunters, and we do the cost-benefit analysis and we look at their preferences, what we're doing is we're having a debate that should be about human values, that should bring in the full sweep of security, privacy, autonomy, happiness, human flourishing. We should bring in methodologies other than the kind of narrow confines of economic analysis. We should do all of this in this very broad, capacious way. But instead, what we would do is we would have this very narrow, economically focused conversation because for some reason we've decided that that's value neutral. But of course it's not. It instantiates deep embedded values like economic efficiency and utilitarianism that for some reason economists have convinced themselves aren't really values at all, but kind of part of the background ether and neutral in that way. It doesn't have to be that way because I'm almost out of time. I'll tease this and then say more during the back and forth.
Yeah, very short.
Through the history of the law, we've passed many, many, many laws, including privacy laws, that are not premised on this sort of singular focus on economic analysis, and I'll say more about that soon. Thank you.
Wonderful. Thank you very much, Professor Hurwitz.
Okay,
5 minutes.
What in many ways we're talking about isn't privacy. Rather, our discussion is largely about a generalized discontent that's being framed in privacy terms. So I agree with Paul. There are lots of harms that we can identify. I wouldn't categorize these as privacy harms when we say we don't want cell companies, and we'll delve into the cell company, the bail bondsman story later. There's a lot of important detail that the motherboard story ignored in order to make a sensationalized story.
As did Paul.
As did Paul, but we'll talk about that later. If we have a specific law addressing a specific sort of harm, I would say we're no longer talking about a privacy harm. Rather, the thing animating our discussion is that we've got all these large technology platforms, we've got a lot of stuff we're seeing going on in society that we're not comfortable with, and we've decided to frame our discontent with these issues in privacy terms. To some extent, this is because folks like Paul have legitimate concerns that he thinks of in privacy terms. In other cases, it's because low-quality press and media, because advocacy groups that are concerned about shaping the contours of discussion to get their preferred outcomes are willing to mislead the public and say, hey, look at this bail bounty story that we're going to tell you about, omitting the key facts that you need to really understand it, and we're going to tell you this is about the cell phone companies abusing your privacy rights in order to make a quick buck or harm you. So what do I want to say? People kind of suck. Modern technology is bringing this suckiness out at scale. It's possible that modern technology is bringing out our lesser angels and actually making us work. It might just be shining a light onto who we always have been and already are. Now, for some reason, we've attributed these problems to the context of privacy, the collection of information about us. Now, if we go back, this is my framing, how I think about this, if we go back to the earliest law and econ analysis of privacy, Richard Posner, and how he thought about privacy. He spoke about privacy as the way that individuals make markets less efficient by concealing disfavorable information about themselves from the rest of the market. So I don't want you all to know that I believe horrible, terrible things, so this gets published about me, I sue whomever published it, so that I can go about my life continuing to be a terrible, horrible person and engaging with the rest of the society. From the economic perspective, that's inefficient. We dislike privacy from that perspective. But what we're seeing today is a different sort of discussion, a different sort of concern. Rather, what we're seeing is in this modern, socially networked, high-tech world, what we're seeing is a reflection of who we are. And we kind of don't like a lot of this reflection. So my concern is that the privacy advocacy movement is largely about saying, we don't like what's being revealed about us. We want to continue going on being horrible, terrible people, being small and petty on Twitter and having meaningless fights and following clickbait articles and chasing confirmation bias. And instead of confronting our lesser angels and trying to improve who we are, we're just going to use privacy to soothe these platforms into not engaging with us on these dimensions so that we don't need to look in this mirror. So that's my concern about how the privacy movement is being used. Now, what is an economic harm? So Jeff spoke about this. The economic way of thinking is about trade-offs. And in order to make trade-offs and evaluate trade-offs, you need to have metrics. You need to have measurements. You need to be able to say, well, this is what X's cost is. This is what X's benefits are. How as a society do we figure out which one of these we prefer? If as a society we say this is a hard, nebulous question, so we're going to get together and through the political process pass a law that places a thumb on a scale. We're going to say location information is special, so we're going to pass a law that regulates its use. I would say this is an economic judgment. If, on the other hand, we're going to say, you know, we've got nebulous concerns, we're going to throw out standard principles, standing principles of concreteness and particularity and chains of causation and clear damages, and just let Paul bring a suit against Facebook because he doesn't like Facebook's practices. No, that's not how we want these norms to develop, because then we've got particular entities with trump cards in the political process that are going to have outweighed voices. So going back to KC's comments, measurability.
And what Casey teed up for us is still resonating.
You had your time.
Yeah, really.
No. I know this feels like wrestling, but this is not tag team wrestling, so you can't tag Casey. So, Professor Cetron.
So I'm going to pick up where my colleague left off, and understanding harm as a setback to interest. And we're addressing where law doesn't address at all or inadequately addresses a setback to interest, and where we wouldn't understand it necessarily as an economic harm, so non-economic harms, okay, non-economic setback to interest. And so I'm going to just provide two examples where we have a serious setback to interest that law inadequately or doesn't at all address, and that doesn't lend itself necessarily to economic terms, okay? And it's not about, I think it's easy to marginalize these stories by saying, oh, you're trying to hide embarrassing information about you, or I don't want to look bad in your eyes, or I don't like what Facebook is doing, but that's just a trivialization of the setbacks to interest. So one example, a woman, she's a young lawyer. She goes to a hotel on behalf of her law firm, and she's secretly taped in the shower. A hotel employee placed a camera in the shower, and she leaves, she does her business, and about a week later, the video of her showering ends up on Pornhub with her name attached. And she did a Google search of her name, and she finds this. And she then asked Pornhub, racking her brain, how could this be, to take it down. And Pornhub takes it down. But as soon as Pornhub takes it down, the same video pops up on under a different username. And within days, the individual, the hotel employee, who we believe it is, right, contacts her and says, give me more nude photos of you, or I'm going to send the video of you showering to your law school classmates and to your employer. And she calls me. She's not going to send, I talk her out of sending any, well, obviously she's not going to send the nude photos. He does precisely that. She is struggling with and continue to struggle with taking down the photos at Pornhub, because as soon as she complains, as soon it comes back up again. And so what's her setback to interest? Her setback to interest is her emotional harm, her harm to her sense of her own sexual identity and autonomy. As she said to me, I'm just tits to these people now. All these people I thought I had their respect, right? My coworkers, my colleagues, I'm not a whole, fully integrated person anymore. And she's terrified, right? There is now an increased risk that she might be physically confronted by someone offline who have seen these videos. So that's one example. So we have a setback interest to human dignity, to sexual autonomy, emotional harm, right? Psychological damage. All we wouldn't understand as lending themselves easily to economic, though throughout history law, I know Paul's going to explain, we've long recognized some of these harms as harms to integrity, personal integrity, human flourishing, right, and emotional harm. So the other is mSpy, is a cyber stalking app, essentially, that bills itself as providing a way for parents to keep tabs on their kids, but what mSpy does is allow for the secret surveillance of everything you do with your phone, wherever you go, whatever video you look at, whatever address you add to your book, as well as turning your microphone on your phone so that everything you say and do is recorded, right? So again, is that harm, is that setback to interest? So someone who is secretly taped, communicating with loved ones, right, in ways that you wouldn't want anyone else to hear. Can someone who's had and then finds out that an ex-lover has put that on their phone? It's an interference with one's sense of safety and trust and intimacy, right? How are we going to trust someone else with our phones, right, with our sexuality, with our vulnerability? And so the interference here is undermining one's sense of integrity in relationships.
Very good. Thank you very much. And we actually gained back a few seconds there. So we're going to move to Cross. So what I'm going to do is to ask Jeff gets 5 minutes, and then Paul, you can spend your 5 minutes grilling the other side. Off you go.
Okay.
Wait, I missed that. 5 minutes.
He gets 5 minutes.
So it doesn't have to be questions.
Yes, it should
It could
be
just be
questions.
grandstanding is what, no, okay.
I'm not a lawyer.
You
but
mean
I'm
like you're
sure-
doing
I'm
right now?
sure that you can find
My
a way to
time hasn't
transform
started.
through questions. I mean, many of the people in this room have been in congressional testimony.
Yep.
Right? But hopefully it'll be questions and good answers because this is Silicon Flatiron.
Yeah, sure. There you go.
Okay, so I guess the first thing I want to ask is, so you said you gave the example of the bounty hunter location database, and I'm actually going to let Gus go to town on the inaccuracies
Go to town
of
as
that.
much as you want.
Well, no, because I want to ask a preliminary question that first comes up. So you said though, you're right, like you referred to this as though it was sort of self-evidently a harm, but can you explain to me what the harm is? So and let me be more concrete here. There's an obvious harm to someone who is injured or even whose photograph is taken as a consequence of someone being able to find them when they didn't want to be found. But you're suggesting that the ability to know where someone is if they don't know or don't want that to be known is itself inherently a harm. And I don't understand what I'd like you to tell me what the harm is and how you would possibly measure it, how you would possibly quantify it, and if you acknowledge that for certain uses, maintaining a database of location information could be valuable, how you could explain to me that that unless you think there is no value to actually maintaining that information, how you could maintain any way of distinguishing between harmfully collecting that data and not harmfully collecting it.
So this is a good opportunity because I think in both of your opening statements, you kind of made this conflation, which just isn't true, and it's a kind of conflation that economists do all the time and don't realize they're doing, which is economic analysis is the only path to what were some of the words you used, concreteness, identifiability. I mean, certainly there are lots of other ways society has figured out ways to talk about things like potential harms and agree in kind of very concrete terms on what is a harm or what isn't a harm. So let me just do one historical analog.
I don't want to.
I'll give you a historical
I want you to
analog.
answer my question. I'm
19
going to channel Congress.
So 1968.
I don't want to know about 1968. I want to know why what I asked about is a harm today. I don't care about whether it was in 1968, although I'd point out things that were harms then aren't harms now.
Okay, so here's the question I hear you asking. Why is it harmful for a third-party company you've never heard from to buy from a shady second-party company you've never heard from, to buy from a first-party company you've never heard from, where you are 14,000 times a day for years and years, or maybe flip the switch that'll let them track you in real time. I think it's a little self-evident, but maybe you disagree.
Tell me
Yes,
why.
that there are people who are stalked, that there are people who are hunted down and murdered.
Stalking is a harm.
Yeah,
Got that.
that's
no
right,
problem.
but it's
no
it's
problem
the-
with that.
so we have
I don't
laws
have any
all the
problem with
time.
stalking being a harm.
Yeah.
I don't have any problem identifying the things that Danielle talked about with being a harm. I have a problem with understanding how the ability, let's say, the risk of stalking is itself inherently a harm, and again, one that, that as far as I can tell,
What about
is
the-
given infinite weight.
So we have tort law, we have lots of laws that focus on things like anxiety, that focus on risk. I'm not sure why this seems like
Oh,
such a
it's
novel
not- it's
turn
not
in the
just
law that
about
we're proposing
risk.
here.
Of course, it's not just about the risk of that. Again, the
Absolutely,
you
it
don't
is.
no.
No,
You
this
don't
is
define
exactly
it,
what
no.
you just said. You
No,
said the
you
risk
don't
that
define
someone
it.
might
Excuse me,
stalk you.
excuse me.
Yeah.
You don't find it as the risk of stalking.
Yeah.
You said that the harm is the knowledge of that location information. Now, again, if you were defining the harm as
Oh, I know exactly
stalking
never said
and
that.
the
You're putting
risk
words in my
of
mouth. I
stalking-
never said the
Oh.
mere knowledge alone.
Oh, okay. Wait. Oh, so
is-
that's good to know. All right.
Yeah, yeah.
So it's not actually the unauthorized revelation of information. It's only the unauthorized revelation of information that has a risk of leading to something that we could all agree is a coate harm, if that's even a word.
First of all, I think it goes without saying that even under the narrower constriction that you just put there, the narrow, the risk of harm, absolutely, that's satisfied in the hypothetical we're talking about. So we ought to have a law, the risk of stalking, the risk that,
Yeah. Okay. That's fine.
Yeah.
Sure.
So
Fine
we
with
agree,
that.
but that's not an economic analysis. You notice that? Never once did we say incentives. Never once did we say, well, what are the trade-offs to being stalked? Maybe it's okay to have a risk of stalking because you might enjoy being stalked by the person who's stalking you.
But we're
right? You
also-
notice how what we're doing is we're
But
having
we're
a
not
very
talking-
different
okay,
kind of discourse.
excuse me.
We're not having
talking
an
about
economic
pri-
discourse
But we're
here,
not
yeah?
talking about privacy either.
Sure we are.
This was Gus's point earlier. No, we're not though.
What's the-
Stalking
what's the
is not
question?
privacy.
What's the question?
I'd still like the answer.
How is
to-
stalking not privacy? Privacy is a term that we fight over
You
the-
get to ask the question
Okay.
in 2 minutes. Actually, in 20 seconds.
Now,
So-
are we asking questions of just our equivalent? Is that how
No,
this
no,
works?
you get to
Oh,
ask
it's just,
the
it's just
question.
that I only
You-
got one question. out. I mean,
Equal in every way.
And if
not-
this
you know,
were Virginia, we would have a duel. Yeah.
not a
right.
waist size thing.
Yeah.
I mean, come on.
Oh, hey.
All right.
That was a
So
personal dig.
you have very successfully run out the clock.
Yeah, but this part doesn't count. You asked what the
And-
question is.
Yep. And so, Paul, you now get to cross-examine these gentlemen.
So again, let's talk about pre-existing laws and whether we ought to remove them from the books because they're not. I would at least say they're hard to justify only under economic terms. So we have the most popular thing the Federal Trade Commission has ever done is do not call. And the commissioners who and there's a checkered history, and I know you know it really well. And they said, what we're talking about here is the quiet enjoyment of the home. The same phrase that was used when it was discovered in the designer wear case, that rental laptops were filming people in their homes. There was no economic analysis in the designer wear case to speak of. I mean, there might have been a little bit of keeping the BE lawyers happy toward the back of it. But the commissioners, including some kind of conservative, quote unquote, Republican commissioners, said the quiet enjoyment of a home is a different articulation than other privacy cases that we've faced before. And so we're going to have the FTC power extended to this. So is that something we should roll back? Is it hard to justify something like do not call, canned spam, do not track under non-economic terms? And so for that reason, should we remove them from the books?
So Jeff's our attack dog, and I'm our reasonable one.
I'm not supposed to say that out loud.
No. Bad cop, good cop. No.
But if you let them
we've-
know.
I know, I always do that. I don't believe in privacy, so I let them know.
Apparently, full transparency is the name of the game.
So we have we run the risk of having a debate over semantics. And in many ways,
Sure.
we are having a debate over semantics.
Yep.
What is an economic harm?
Yeah.
Are we talking
What
about...
is privacy? We've already done that.
Well,
right?
we'll come to what is privacy, but just what do we mean by economic harm?
Right.
Do we mean in the tort law conception of economic harm, or is there a dollar value assigned to this? My response to your question is Coase theorem.
Right.
My response to your theorem, my response to your question is there's lots of regulation that is about harms to people that we can't quantify, or perhaps we could quantify, but the dollar values are so low, or putting a dollar value on it is so difficult, or the transaction costs, Coase theorem, of actually going to litigation and demonstrating all this stuff, the information costs and other transaction costs are so high that we're not going to go to litigation or rely on common law sort of approaches. So this is why we have things like the FTC to say, okay, and do not call is a great example. The transaction cost of expecting people when they get unwanted phone calls to litigate and negotiate ex ante with all potential callers, that's impossible. So instead, we're going to have a more efficient market clearing mechanism, the do not call list, along with agency enforced fines for violations of abiding by this law, because it's more economically efficient to remedy this harm or limit this harm that way.
So I think it's cleaner and more honest, and we can have a debate on values to say, you shouldn't call me during dinner, and you shouldn't video my kid in my living room, right? And so part of the problem with economic analysis is it gets lost in the kind of word salad that we just heard for the last minute. And instead, so you're taking this round trip through a seeming rigor, when instead what you're really saying is, look, we know that's a harm. We know it's a harm that's important enough to have something like a regulation or enforcement action against. So the Wiretap Act is another example. Should we do away with the Wiretap Act? I think under any sensible economic analysis, the Wiretap Act overprotects, right? It says, thou shalt not have an Amazon Echo, which I think are probably felony violations under the Wiretap Act. Thou shalt not, have a surreptitious thing hidden on your body. Thou shalt not tap a telephone call, notwithstanding the kind of innovation that no doubt we have killed for decades and decades, right? So should we rewrite the Wiretap Act to kind of cabinet? Because when we wrote it at the time in 1968,
I think we have a question.
We said,
we have a question.
We said, we as a society decide that because of the threats of unchecked surveillance of this kind, we're just going to prohibit it.
So first, I'm all for updating and modifying it in many
Yeah.
ways. I think we don't want to get rid of it for a really important reason. MSpy. When you have an app, you have a device that's surreptitiously recording, that is a violation of the Wiretap Act. So we have another a statute already there as a backstop.
Yeah, but isn't it just the transaction costs are not quite there, and maybe NSpy is a good thing in certain cases? I mean, even Danielle said that that's how they're holding themselves out to the
Get
public.
themselves around 2512 by saying they're not primarily used for surreptitious surveillance, when in fact they are, and they get to have advertisements saying it's for kids and parents and schools and teachers, and it's nonsense.
So you guys
they're
get the
not
last
subject
30
to
seconds.
I think one of the things that goes into this that is an important part of the economic analysis, and that it doesn't require you to have the harm that we're talking about collapse into dollars, is the notion of, again, of sort of what the violation is, right? So in the case of something like NSpy, there's arguably a contractual violation, deception. There are sort of forms of interaction that I think we can agree are clearly problematic from an economic or other standpoint, but definitely from an economic standpoint. The harder thing is when there isn't a deception, there isn't any kind of a definable invasion of the sort that you mentioned, where we're just talking about, say, for example, some bit of information that is known by others and that is unauthorized.
So that's a good place to call a halt, and over to go.
Okay,
Let
so
me finish that thought.
no, because I've got one brief, short, concise question I want to ask each of you.
Sure.
Paul,
Yes.
Danielle,
Gus.
Gus! Like,
privacy.
I define it clearly a lot more broadly than you do, because what I heard Jeff say not too long ago was tracking someone through this GPS location information and stalking them is not a privacy harm, which is kind of not consistent with that word, even under the kind of narrowest definitions that I've heard applied to it. So the classic definition, and honestly, I think I can rest on the classic definition, although it's insufficiently narrow, is the right to control information about yourself. It's the kind of bedrock of privacy tort law. It's the bedrock of many statutes. And even then, I think a lot of the examples we're talking about speak to harms that, again, are easier to describe without this crazy word salad round trip through incentives and transaction costs and costs. And so to me, even that definition, I think, backs everything we've been saying this whole time.
and I'm going to build on what Paul said, because we're in heated agreement, which is that should be obvious at this point, right? That Warren and Brandeis is right. To control what others know about you also includes the right to control revelations of the central self, right? Whether it's your thoughts, it's your emotions, it's your sexual fantasies, your beliefs, your online searches, the nude photos you took of yourself you don't want anyone else to see. And I guess where I would may I ask a question of them? Am I
You're-
busting out of
you-
my?
you get-
about
you
it.
get
You're gonna
5
turn in a
minutes of your
second.
own.
You're going to get your
Okay,
chance.
so that's my answer.
So, interesting that you both frame it in terms of control.
To be clear, we could go broader. We could give you a,
could go even
we can give a
broader.
disquisition on 17 other theories, but
And
control, I
it's
think,
not
is enough.
hinging on, I think, to be clear, we're not hinging it on like a notice and consent regime. There are sets of understandings. Take non-consensual pornography, right? There are two people who have sets of reasonable understandings. Let's say, for example, a nude photo is for their eyes only, right? And the other person betrays the trust and sense of confidentiality and understandings and exposes the person and reduces them to their vagina. Excuse me, but that's what it is, right? So it is the idea that you have control. It's not just about control. It's about the unwanted exposure, non-consensual exposure of revelation of oneself that one wants to keep to oneself.
So,
anything?
really interesting framing there.
I'm using sexual privacy as my frame at the moment. That's
My time, Jeff.
I'm-
time.
it's my bugaboo. I'm writing a book, so I'm staying with it. You know?
Interesting that you both frame it in terms of control, because it has to be noted, Paul is dismissive of Coasian analysis and Coase and everything that I believe in, hold near and dear. But we're talking about property rights. I'm going to give Paul a Gorsuch here and say when we're talking about property rights, we're talking about the delineation of who gets access to what sorts of information.
Yeah, but you know what? Locke is a moral philosopher. And owning oneself is not about the kind of way in which we conceptualize property in economic terms. So I think that's a fallacy.
Difficult operation.
I want to see the tweet that comes after that exchange. Because you got your Coase, you got your Locke, mic drop.
Where's Wendy Gordon when I'm here? Need her.
So, Paul, you suggest that we who approach these issues from an economic sense are overly narrow.
Yeah.
My pushback and my question is that your approach has no boundaries. It allows for unfettered discretion and unclear rules. What are the boundaries? What are the boundaries of privacy from your perspective?
So every law that I've been talking about, be it the Privacy Torts Wiretap Act, we could talk about COPPA, we could talk about a whole host of laws that are not economic, communications law, CPNI, right? They rest on things like concreteness. They have factors built into them like highly offensive to a reasonable person, right? We're not talking about an unbounded Wild West where every single entrepreneur is going to have their company smothered in the cradle. I've just given you two.
What are the boundaries of the FTC's privacy enforcement?
Sure, right. It has to be harm. Well, if we're talking about unfairness, it has to consist of harm, right? And then you've got that ridiculous 1980 policy statement, which...
The FTC has effectively disclaimed there's a possibility of harm.
Sure.
So
That's even better, right? That's
from your perspective,
risk. That's the word risk, right? Yes.
What are
Thank
the
you.
boundaries? What are the limits of a liability under a possibility of harm framework?
So I just said, obviously there is a, as you know, a theorists have said, a common law feel to the way FTC decides these things. I think they're going to look for things like highly offensive. So you're unlikely to say,
Like in LabMD.
you're likely to see the FTC say,
Very highly offensive.
okay,
You're saying you think they are going to possibly.
Sure.
So this is the value of the economic framework, and I recognize there are challenges here, which is why I say.
there wasn't an
no,
economic
okay,
framework
thank
before
you.
1980.
All right.
We're giving texture to statutes. So.
Very good, very good. So now, Danelle, you get your 5 minutes to ask questions.
So I think I hear you guys conceding that a setback to an interest may include concerns that you don't have to balance against or trade off, right? So take non-consensual pornography, right? It's true that when two people take a sex video, there are two individuals involved, right? And let's say at the making of the sex video, the understanding is it's just for their eyes only. But let's just imagine, which happens all the time, that one of the partners changes his or her mind, right? And it's their sexual privacy and sexual expression that is in tension with the other partner's sexual privacy and expression, right? I contend, or I think we contend, there are some setbacks to interest in which we're not going to balance. There are no trade-offs. I don't care about your sexual privacy, and your sexual expression. Would you concede to that? Because isn't your whole shtick about having to have trade-offs?
So I would say that as
If I'm from New York, I can't help myself.
So I would say that we as a society, trade-offs are hard to make in an economic framework. We go through a political process, and we go through due process.
That seems like such a cop-out.
Give him a chance to answer that.
Because if we don't have some political backstop through this process, some due process, some societal discussion, then we have unfettered discretion of enforcers. And you're choosing the clear example. Obviously, I agree with you. Obviously, I assume, well, I don't
That is
know.
not obvious to everyone. I'll be honest, it's not. I've struggled to get laws passed in the 50 states and 6 territories and on the federal level. So I'm just going to disagree. It's lovely you agree with me. I'm excited.
Well, that's not.
But
I mean,
I wish everyone else
don't you think that okay? I'm answering her question.
Okay.
If she wants to stop me, she's
Okay, no,
welcome
no,
to.
fine. You were
Yeah.
framing it as a question, so you said, don't you think? So
Well, okay.
please answer.
Well, yes. Fine. Don't you think that I'm right?
Stay seated if you think that we're right.
It seems to me that the examples you're using are sort of not very useful precisely because they are, despite the difficulty getting laws passed, which may have nothing to do with the sort of general sense that this is kind of an obvious case where if there is a countervailing benefit, it's trivially small and we don't care about overcoming it. I mean, I'd be hard pressed to define what it would even be, but let's just, I think that's sort of obvious in those cases. And the bigger problem is not with the specific laws that you've mentioned, or even with those sort of specific cases. It's really this more inchoate sort of idea of privacy as an actionable thing without the kind of specificity that you get from some of the laws that you mentioned. And there's a reason that Gus was talking about Section 5 in the FTC, because that's a pretty good example of a law that has virtually no specificity, at least in the way that the FTC has interpreted it. And as applied to privacy, I think it's it's a reasonable question to say, or it's a reasonable statement to say it has no limiting principle, sort of the way the FTC has looked at it. So that's, at least for me, that's the objection. The kind of examples you've been giving seem to me to be obviously out of that realm.
Can I broaden it to include Paul's wonderful work on sensitive information? That I would say, if there are privacy interests that are at the apex of privacy interests that we really ought to value because they're so important to human dignity,
Right.
autonomy, and then more consequential rationales, health data, right, shared in a confidential circumstance.
But it depends on-
No, let me just ask,
Yeah,
right?
yeah.
Think of all the ways in which we do provide safeguards for more sensitive, what we understand as sensitive data, but that's based on human values, right? Where we are worried about autonomy. We're worried about chilling of free expression or any expression.
What's the question?
So the question is, if I broaden out the categories, you're telling me I am setting up a straw man, I just disagree with you about non-consensual pornography and sexual
straw man.
privacy, that if I broadened it to include Paul's wonderful work on sensitive information, that
Do I have to concede it's
would
wonderful?
you agree? And you don't have to say it's wonderful, but I do. That's okay.
No,
I think
I
it's
just wanted to
wonderful,
make
actually,
sure.
Right, read it SoCal Law Review just saying. Okay. So if you broadened it, I guess my question fundamentally is about, would you concede that there's a setback to interest that we wouldn't balance? There are some information that we think is inherently sensitive or dangerous because of the way it impacts autonomy, human dignity, discrimination, et cetera. Would you concede that?
Because of the
I'm just
way
broadening the
it,
category.
get
so
to
I
a
can,
second.
It seemed like
I
a big
definitely can
trivial.
see it with respect to the. I would concede that with respect to information that can lead to obviously concrete harms, right? Even if it's a relatively small risk where
Including
they're
autonomy harms?
obviously.
Okay.
I would
Well,
I
I don't
would
know.
note,
So,
setback to
last
interest.
word.
Setback
The
to
moral
interest.
philosophy understanding of harm.
No, that's an economic sort of
Well,
language.
you can take
Okay.
whatever you want, but I'm
Thank-
Joel Feinberg. so,
Thank you
okay.
very much. We'll let the audience ultimately decide on this. Actually, not quite yet, but so what we're going to do now is we're going to wrap up. Each of the speakers gets 2 minutes. So when Jeff and Paul have spoken, actually, no, I was wrong, Vanessa. Do bring up that. This is you're going to see the URL for the second poll. You don't have to vote now. You can wait until the final persuasive words, or if your mind's made up, you can vote now. But 2 minutes for each of the speakers, the same order. Go.
Not questions, right?
No.
Okay.
No. You just get to say how dumb their arguments were.
Well, I'm done. Okay, so I think the really crucial thing here is the lack of concreteness in the sort of concept of privacy as I see it being operational, or attempts for it to be operationalized, starting with the FTC, but going to baseline privacy law, whatever it is that people want. I think no one disagrees, and it is a perfectly susceptible to economic understanding and analysis that there are egregious harms that don't have that our society has agreed don't have countervailing benefits, and we deal with those by passing specific laws to preclude them. That's not the same thing as saying we want privacy and we sort of know it when we see it. You mentioned Warren and Brandeis, which I think is really interesting because, of course, that whole thing was instigated by the rise of the Kodak camera. And if we had taken at that time, if we had taken their approach and just said, you know what, the risk of harm from the Kodak camera is so massive that we should ban it, looking back, we would say that would have been ridiculous and absurd, I think we would say, despite the fact that some of those Kodak cameras are used to take pictures of naked people and abuse them in all kinds of horrible ways. But because we understand that there are valuable benefits on the other side, we don't just jump in and ban the technology because it might conceivably possibly lead to some harms. And that's the approach that I think is untenable here. So that doesn't preclude, as I said, laws that address very specific problems, that provide very specific legal steps for demonstrating those problems, right? That does preclude, however, operationalizing things like the Section 5 of the FTC Act, which doesn't require a baseline standard, doesn't require a duty, it doesn't require causation. It basically allows the FTC to say, we imagine that this could be problematic at some point in the future, and therefore your holding of this information, your collection of this information that could conceivably one day be released in some fashion is actionable.
Thank you very much.
Isn't sustainable, I believe.
Very good. Paul, 2 minutes.
I'm glad you brought up the Warren and Brandeis example because it exemplified what I heard from your side throughout, which was mischaracterizations of what the other side was saying. Warren and Brandeis did not ask us to ban the Kodak camera.
They
said we ought to recognize.
That was a
I didn't say that.
We ought to recognize four new torts. And you know what we did through the work of Dean Prosser and the states and the attorney generals. And you know what? We have these four torts that are probably kind of hard to explain if it's just a balance of costs and benefits. But if instead we're looking at things like concreteness and limiting principles, we have these four torts that are quite vibrant on the books. We don't have to convince you, I think, again, because of the tyranny of the adverb, that all privacy harms ought to have a law that would prohibit that or restrict it. We just have to convince you that there are some harms that are hard to talk about in economic terms that don't lend themselves to transaction cost analysis and costs and benefits and costs, but instead that are susceptible to other sorts of reasoning that, although granted do not happen in the halls of economics departments, they happen elsewhere on universities like this, nevertheless they're rigorous, they're backed by social science, and they're the kind of conversations that too rarely happen in Washington, D.C. So I think if you agree with us that there's even one new privacy law that could be based on that sort of analysis, I think you have to vote for us.
All right.
I don't.
Okay, so first, if I were sitting in your seats, I honestly don't know which way I would vote because we have a semantic issue here. We're not really talking about economic harms. We're talking about limiting principles. A couple of quick points. First, classics of the law and economics literature. I'm going to give you a quick view from a cathedral. Melamed and Calabresi. I'm speaking really to one person in the audience.
That's how we've narrowed down the debate. Yeah.
Most people are,
You don't have to talk to Barron. You've already got him.
Most folks think of Melamed and Calabresi, property liability rules with 2 assignments. You've got 4 possible rights. There also were rules 5 and 6, which deal with inalienability rules, things that we think people shouldn't be able to transfer. That's kind of what privacy rules are about. Fits into a law and economic framework. The basic concern that Jeff and I have is there's no limiting principle when it comes to these privacy rights. To give you one example of the incoherence that this can lead to. In the 1990s, caller ID was a new technology. I expect we all love it and depend on it. Privacy advocates opposed it because they viewed it as an invasion of privacy. What the hell does this mean? The basic, going back to Casey's comments earlier, focusing on measurement, I would add something to the measurement analysis, which is identification. In order to have a coherent conversation about whether or not something is or isn't a harm and should be prescribed, we need to be able to measure it or identify it. If you can identify it, you can pass a law. We can say this is something that we can't measure, but we can say this is the benefits are we can't measure, the harms are clear, let's prescribe it. If you're okay with that, then I think that you're okay with this understanding that we need to have some limiting principle of privacy regulation, in which case you have to vote for me and Jeff.
Very good. Professor Citrin, you get the last word.
Sure. So I love being invited to talk about Warren and Brandeis.
Yeah.
Because the story that they told was about familial and sexual privacy. Sam Warren's brother was gay, and he did not want his family subject to both the emotional suffering, the score, and potential criminal liability if his brother's homosexuality got out. Remember, we're 1890. And they talked about the sacrality of the domestic home, that whispers in the closet should not be shouted from the rooftops. They were not banning cameras, right? They were talking about the sacrality of the domestic occurrence, that even the most unrevealing letter that Sam Warren and Brandeis write, even the most unrevealing letter between father and son, that if they didn't choose to publicize it, then that was covered by the right to one's inviolate personality because of the sacrality of domestic relationships. I'm just ending there.
Thank you very much. So in a few moments we will, but not quite yet, we will bring up the results. But before we bring up the results, I want to do something which I guess one can do because we're in Boulder, which is to say that everybody wins. This was great.
Good job, guys.
I'd like to thank all our debaters. I'd like to thank you for being here all day, for joining us here today. We have our dinner this evening, and we'll bring up the result of the poll. I hope you enjoyed the conversation. I think there was a lot to be learned here. And actually, I'm looking forward to...
Hang on, refreshing.
There we go.
83.6, right? That was our baseline?
Oh, we got killed. 3069.
We're terrible people, everyone.
People kind of suck.
It just proved it from your perspective.
Okay, so the first vote was 100, the second is 92. But I think this side actually did shift the conversation.
It's all
Thank you
coast
very
from here
much.
on out.
We should be so lucky.
You guys were amazing.
When I saw that initial vote, I thought, there's no way.